That was a really great presentation, because I'm like Kevin, I don't know anything about workers' compensation, but I have a big Rolodex and all y'all's names in my Rolodex, so when I have a question, I know who to call. Okay, so what are we going to talk about this afternoon? We're going to talk about long-term disability insurance policies under ERISA. Why is that important at a plaintiff's workers' comp closed-door retreat? It's because most every one of your clients who you're helping is probably also insured and covered under a group long-term disability insurance policy with their employer. If it comes to a point where they can no longer go back to work at their own occupation, then they may have benefits under that policy. And there are things that you can do to totally eliminate that benefit for them. Okay, so just be aware of that. And there's things you can do to really increase the amount of dollars they get in their pocket, and that's at the end of the day what we want to do. Let me tell you what, I have a little timer up there supposed to go. Now I need it. All right, so let me tell you what I gave you in the materials. One is it's the knowledge book that we use in our law firm to teach everyone about these cases. I do not think that you need to become an expert in ERISA. You do not need to become an expert in long-term disability insurance claims. You need to know enough, because if your client is in a position where he or she is not going to be able to work in, and they are insured in one of these policies, they're going to come to you first because you're already representing them. If you give advice, we want it to be good advice. All right? So this is the knowledge book that we use to train our teams. The second is the manuscript. So part of what we're going to talk about here today is when you settle your claims, there is a way in many cases to maximize the benefit that your client is going to get under his or her disability insurance policy, and there's a way to mess it up. All right? This tells you exactly what you need to be thinking about and what language you need to put into your workers' compensation settlements. And then my thing, because I work with many of you now, is just give me a call. All right? As you're getting close, especially major cases with major dollars, just give me a call and we'll walk through it. So we're going to talk generally about these cases, framework of the cases. I'm going to give you some things to talk about. And at the end, because I always do stuff that's not legal, right, or not just strictly involved in the law, got a couple of free things for you. Now, does anybody here, because I'm a soccer referee, long time, I'll start my 50th year refereeing youth and high school soccer next year. Anybody here have a teenager who's a teenage soccer referee or baseball umpire or anything like this?
Not yet, but
best paying job at Fairfax.
Yeah.
There you go. So this is for your kiddo. It's not about the rules, it's about the mindset of getting through those first couple of years when you can't be good at what you're doing. Okay, so where does this come from? This practice area discovered me about 25 years ago. I just thought it was a simple insurance case. I didn't know what the hell I was doing, and I got my butt kicked for several years, and then we developed systems. Today we do the most number of these cases in Virginia in terms of filed cases in federal court. We have a lot of cases in Virginia, up and down the Fourth Circuit, and now across the country. Part of what we'll talk about is I want you to understand the sort of procedural, how these cases proceed. And then at the bottom is a big number. So we have over $33 million of future claims under management. And we're going to get paid a part of every single one of those dollars. So just kind of think about that. If you're looking for another practice area, it's a vastly underserved practice area. I've got a whole team that's devoted to keeping our clients on claim once we get them on claim. And when you think about valuation of firms and selling to private equity or to another lawyer in the future, that's a big number. You all may have that too, because I'm not exactly sure how you get paid. You have these clients for years and years. I don't know if you get paid on it for years and years, but we do. How many went to the Sources of Coverage seminar? Really? I'm shocked. Everybody knows this. How many, Andy, how many of those have you been to over the years? The Sources of Coverage, VTLA seminar, automobile policies, right? You remember this? Lots of them, right? And Jerry Schwartz, for years and years, he owned that market. He was the seminar for the whole day. And one of Jerry's very first slides that he put up on every seminar was read the policy. okay? So that's rule number one. If a client's coming to you to say, hey, I've got this long-term disability insurance policy, and you're gonna give any advice, you gotta get the policy. And we believe you have to get the policy that was in effect on the day that they became disabled, unable to work, and you probably gotta get the policy that's in effect now, because policies can be amended. How policies allocate your workers' compensation settlement can change. Whether or not a workers' compensation claim is a bar of the policy can change. So you have to get the policy. Usually the policy is an insurance policy. You get it by writing to the insurance company, typically, who is managing the short-term or long-term disability insurance claim. You just got to get it and you got to read it because they're all a little bit different. Now, most employers have disability insurance policies for their clients, and many of these big firms have ERISA plans, all right? And you'd think like they would get this all right and everyone would have a plan. For those of you who do personal injury work and who oftentimes deal with subrogation issues in your PI case, and it's a ERISA plan, now we're trying to figure out is it self-funded, is it insured, all of that stuff. I'll tell you a quick story. So we had a case earlier this year. We settled the PI case. The plan wants $12,000 of reimbursement. We're getting some conflicting information from the plan, some conflicting documents about whether they actually had a subrogation claim. Turns out in the year that mattered, it looks like they left that section out. We kept saying to them, like, give us a plan, give us a plan, give us a plan. There's a whole bunch of rules in ERISA about they have to give you the plan. They don't, so we do what every plaintiff's lawyer does with a $12,000 insurance case. We file a lawsuit in federal court because ERISA has fee shifting, and we go and argue, because I'm convinced now that this company, which is a major bank, everyone would understand the brand, represented now by a major big-ass law firm, who thinks they know everything and they're going to teach us about ERISA, but they don't have a plan. So we brief the case, we go to argue the case, I won't name names, but I'm 4 words into my argument, and the federal judge is screaming at me, like, why am I so unreasonable? Why am I making him do all this stuff? Screams at me, he leaves the bench. Like, it's a full day Friday, packed courtroom with motions. Dude's screaming at me. Comes back, screams at me some more. I go, okay, but now stop. Because I'm the subject matter expert. I didn't say this, but in my head, I'm the subject matter expert on ERISA in this courtroom. They don't have a plan. I'll bet you they don't have a plan because we've been asking for it for 9 months. So why don't you look over at that other table, Judge, and ask her where the plan is. Oh, of course they got a plan. So he asks her. She kind of dances. So he sets a status con for 2 weeks, like, come back with the plan, get this case. Because he's pissed that a $12,000 insurance case is in his courtroom, right? 3 days later, 3 business days later, they call up and they go, we're withdrawing our subrogation claim. Now, I don't know if it's because they didn't have a plan or they just couldn't find the plan. And they ended up paying between my bill and their lawyer's bill, they ended up paying 3x, the $12,000, all right? So just because someone, we've known, Jerry's taught this forever, just because someone is telling you there's a plan, like, get the document, get it, and read it. Let's just talk about these insurance policies for a moment, because it's important not only to your clients, but to you, especially you young lawyers here who are still healthy. You should be looking for and buying an individual, not a group, an individual long-term disability insurance policy. They're more expensive, but you should get one. They typically will cover, if someone cannot do their job, do their occupational duties, in the first 2 years, they will pay a benefit if you can't do the job that you were doing. After 2 years, it's closer to a Social Security disability standard if they can't do any occupation. Again, you got to read the policy. We're litigating a case right now with a lawyer. He works for MITRE. So this is a public case. MITRE Corporation buys the policy, but they don't know what they're buying, okay? And he's a high-end cybersecurity lawyer, high-stress job, and he's got cardiac issues, and he can actually do his job right now, but his doctors have said, if you keep going back into that cesspool of a workplace, you will have a heart attack and you will die. We call it the risk of future disability, which is an interesting area in our space. So we win on that issue. Then the insurance company says, oh, we only insure you for your own occupation, which for Ben means like the job you were doing, if I followed you around for a couple weeks to see what you're doing, and you can't do that anymore, then you're disabled. And that is the standard. This insurance company, Reliance Standard, again, it's a public case, so we can talk about this. They go, no. Your occupation, Mr. High stressed out lawyer who's working 80 hours a week, on call 24/7, doing high-end national defense stuff. Occupation is lawyer. You can write a will. And that's their position. So my point to you, though, is you should go back and look at your group policies and ask yourselves whether you are really insured, particularly if you're a trial lawyer. Is that policy really going to cover you if you become disabled? We had a case a couple of years ago. We represented a interventional radiologist out of Charlottesville, out of UVA. Guy more at my age cohort, right? Forever has been interventional radiologist, exposed to radiation. He's got some wonky blood levels, and his doctors say, if you stay doing this, you will probably get cancer. So claim, boom. This policy, written by the Standard Insurance Company, said, okay, we're going to insure you for your own occupation. The employer thought, we bought a great policy. We have these high-end expensive doctors. We bought a great policy because it's going to insure them if they cannot do their own occupation. This policy said your occupation is what you're board certified in. My dude was board certified in general radiology. The certification for interventional radiology came really as a result of his work. So he's teaching the residents and the fellows how to be certified, but he doesn't have that certification. And we lost that case because the court said, he can do general radiology. So again, point is, for your own policies, you need to know what the definition of own occupation is. All right. Certain things will be excluded under the policy, and I'll tell you this, in some cases, some policies will exclude a claim if it is covered under workers' compensation. So you just need to know that that's a true thing, but you cannot assume that because you have a valid workers' compensation claim that that person is not covered under their employer's long-term disability insurance claim. Here's another mistake I see some lawyers, but many HR people make. They'll tell people, Julie, you have a workers' comp claim. You don't need to go file your disability claim until your workers' comp claim is over. That's malpractice, all right? Now, that's HR malpractice. In our language, it's a breach of fiduciary duty, which leads to a claim against the employer. But there are time limits. There are time limits on filing these claims. Again, I don't think you need to be an expert, but if your clients ask me, what do I have to do? You have to get the policies involved and read them. Many of these policies will have limited coverage for mental illness, for what they call so-called self-reported, so I have pain, but I can't verify it on radiology, and musculoskeletal conditions. Again, if you're an owner of a law firm and you've got this plan for you and you want to do the best thing for your employees, go look, and if it has any of that language at the bottom, get your broker in. It'll cost you $3 a month more to get a much better plan than this. The other thing you want to do, especially if you have youngins working for you, is try to convince them to pay for the benefit out of their own pocket. It is pennies. It is pennies or dollars a month. The reason that's important is because if they do have a claim and they have paid the premium, the claim benefit will be a non-taxable event. If you, the employer, are paying the premium, then if they have to tap the benefits, then that will be a taxable event. All right, this gives you an idea. So typically, somebody who develops an injury or an illness that prevents them from doing their job duties will start with a short-term disability claim. And that's either going to be for 90 days or 180 days. We call that the elimination period. Again, this is all in the notes I give you. But what the client will ask you is, again, what should I do? Yes, start the claim, make the claim. And at the 90 or 180 day mark, typically they don't need to now reapply. Typically that file moves in the disability insurance company's offices. It moves from the STD, short-term disability section, to the long-term disability section. And then benefits start. Many of our clients who do hard physical labor, so my Amazon drivers, UPS drivers, folks maybe working at Walmart or Starbucks that are lifting heavy things. Those claims are kind of easier because there's a physical nature to their job, and something happens, they can't meet that criteria, they'll typically be protected for 2 years. The harder cases are the knowledge worker cases, right? Because we make money with our brains. We are fortunate as lawyers that we work in air-conditioned and heated buildings. We don't do typically physical labor, but those claims can be harder to make. So there's a lot of cognitive-based claims that you'll think about, at least counsel the client on when they're coming in and they're a sedentary knowledge worker. For those of you who do Social Security, now I don't do Social Security, and let's say I have the same amount of knowledge about Social Security as I do about workers' compensation. But I understand there's kind of a matrix. And if you have a certain disease and you're a certain age, you get paid, right? So you've got a cancer and you're 58, maybe you get paid. That's not true in these cases. The conversation that I have with clients is, what do you do? What are your occupational duties? Are you able or unable to do one or more of those duties? Then, number 3, why? What's the science behind it? What's the diagnosis behind it? So just understand when your client comes to talk to you that it doesn't matter that they have stage 4 cancer of some sort. One thing COVID taught us is that there's many jobs we can do by getting out of our bed, walking to the dining room table, and working remotely. And of course, the insurance industry has used that, to prove that people aren't disabled. Yes, sir?
What sort's the time limit on the long-term disability claim?
Yeah, so on any claim for disability benefits under either a short-term plan or a long-term plan, really the time starts when you have 2 things. 1, an inability to do my occupational duty coupled with an income loss. So for example, so most of my time today is spent counseling CEOs, CFOs, lawyers, doctors all across the country, who do consulting all across the country. Many lawyers and doctors, you could have something going on which prevents you from working, but because of your partnership agreement, because of delayed billing, you might not actually have an income loss. So you need A and B, 1 and 2 to be true when you have a claim. Most policies require you, they give you 60 or 90 days or so to say, I have a claim, and then another period of time to start providing your proof of claim. But even that can be, people can get screwed. Let's just be simple, honest about this. We represent a coal miner in Southwest Virginia, and his policy required him, once he had exhausted his appeal, in a very, very short time frame. If there's no time frame, you basically have 5 years written contract. This one had 6 months. And a venue provision that made us file in the Western District of Pennsylvania. Coal companies screwing coal miners, right? Just argued that case, because we lost it at the district court level, just argued that in the 3rd Circuit Court of Appeals a few weeks ago. If, to the extent that you're counseling clients about perfecting a claim, please do 2 things. Tell them, don't do this at home. Don't, get some advice, either from you, because now you've been here and you've read the notes, or have them call me. We don't really get involved too much at the early claim process, but what we're doing and what you want to do to the extent you're counseling a client is to tell them that the notes that your doctor needs to write, we never tell a doctor what to say, but we are really good at telling doctors how to speak insurance speak, okay? The notes follow the format. I understand that Ben Glass is a whatever, and that the occupational requirements of his job are this in the notes or in the letter from the doctor. In my opinion, he's restricted or unable to do certain of these things, which are a requirement of his occupation, and now here's the science behind it. So we talk about, again, it's not about the disease, it's about whether you're restricted and limited from doing your occupational duties. And the more that we can get that sort of stuff into a record. So people will come to me. Again, most of my stuff is consulting with high-end financial, high-wage earners who have complicated lives. And the first thing we do is we look at their current records. Like, is there enough there? And because what you don't want someone to do is quit their job or not show up, get fired, make a claim, and the records aren't good enough. So we look at the records to see, would an insurance adjuster be able to see what the occupational duty is, what the restrictions are, and what's the science behind it? I assume everybody knows this, and we'll walk through the legal schema for these cases. If your claim is denied with the insurance company, you typically have 180 days to do, quote, an appeal back to the insurance company. All right? If that is denied, you're filing a lawsuit, and it'll be in federal court if it's a most employer plan. So ERISA, there's a slide on this, ERISA doesn't cover like a governmental plan. So our school teachers who have a long-term disability plan, they're outside of ERISA. Our religious organizations that have long-term disability plans are outside of ERISA. All governmental workers are outside of ERISA. But if it is ERISA and you've made the claim's been denied, you've done the appeal, we'll talk about what goes in the appeal, you go to federal court, all right? This is a review of an administrative record, all right? So there's no witnesses. The judge is just gonna look at the language I use to my clients is the judge is just gonna look at the box of evidence and the arguments that you're making from the evidence. So we have a book up here that we give to clients, like, please don't do this at home. Don't do your appeals at home. Okay, so we talked about this. Any plans that you all have for your law firms are gonna be governed by ERISA. By and large, so worthless is a hard word when I say these are worthless policies, but you think about it, the insurance company is selling you these policies without any underwriting. They have to cover everybody. They'll exclude pre-existing conditions. And so the policies they're just not as good as the more expensive brand that you could get by going out onto the market and buying your own individual policy. Again, if you're young and you're healthy, or if you're young and you're not, I would strongly urge you, and go back to your offices and urge your young associates and other employees to consider getting an individual policy. Hungry Vultures was a program by one major insurance company. That was the award they gave every week for the teammate that canceled the most claims and put the most people out of benefits. They use, this is what they'll use, this is what we use. Voc reviews, they're always very, very shallow. So it's really good. I assume many of you have a vocational rehabilitation expert who you can consult with in your workers' comp cases. We do. Again, the important thing is I never tell the voc expert what to say, but my voc expert knows the framework of these cases. Peer review, a bunch of made up doctors. This is, it's wrong to say these are easy pickings, but if you pick your case right, the analysis and thought behind claim denials is so shallow, typically, and there's no lawyer involved, which gives you such a tremendous advantage when you're doing an appeal, because you can put anything you want into your appeal. Of course, you and I are both warning our clients about not only their social media, but being tagged on their friends' social media. Okay. The benefit amount is typically somewhere like 50 to 66% of the wage. With a calculation and formulas, I don't think you really need to know this, you need to read the policy, of if you have other income, if you're getting other benefits, if you're getting a workers' compensation weekly or monthly benefit, however you all work, you just have to know that these things will offset and reduce the payments. And again, most of this is about, well, that's a great slide. You can't read it and it's got 400 words on it. I did that stuff. We talked about this, so we talked about the path. What happens when claim denied, we do the appeal and we win the appeal with the insurance company, they're back on claim. And that's where we'll keep people on claim for decades if we can. And that's where our future, it's recurring monthly income. And I have a whole section in my law firm who's devoted to making sure that once you're on claim, like you're never gonna have to go off claim and you're never gonna have to worry about it because we're gonna be very proactive with the insurance company. The cool thing is Fourth Circuit is, the law is pretty good. I mean, traditionally kind of known as a conservative circuit. The law is pretty good, and the cases are so interesting. I mean, I think they are because I'm an ERISA nerd. I'm happy, when you go back to your law firms, I'm happy to consult with you as you look at your own policies. I do this for medical practices and legal practices. Like, let's make sure that what you think you bought, you have actually bought. All right, ERISA is good for claimants because there's no lawyer on the other side at the beginning. We can put anything we want into the appeal. I put YouTube videos. I found one time one of their experts that they used had been indicted in federal court for disability insurance fraud, so I went on Pacer and got all the transcripts and stuff and stuck that into the appeal. And the cool thing is there's no lawyer, and these people on the other side, they're nice people, they're overworked, but they don't understand ERISA and they're not taught ERISA. All right, so this is the thing you need to know. I know I have just a couple minutes here, but this is what you need to know. This is how how you can accidentally mess this up. You're going to settle a workers' comp case, and the employer says, we want a severance. We want a severance agreement too. Like, we're splitting apart. Like, what's that Taylor Swift song? Like, we are never ever getting back together again, right? And the severance agreements that the defense lawyer sends over to you has that whole alphabet soup list of things, benefits that you are releasing. Nobody ever thinks about this. So one of them is always ERISA. So if you let the client sign a severance agreement that mentions ERISA and waives it, you're giving up, courts have cases, like it's really hard for me to get around this, you're waiving your ERISA claim, your long-term disability claim. Now here's the cool thing, most workers' comp defense lawyers, they don't care, the employer doesn't care. The employer's paid a premium to have Reliance or Unum or New York Life manage the policy. So if you as a lawyer just bring this up, say like, we do not want to waive this LTD claim. Again, if you look at the article I gave you, it has the exact language that you need to talk about, the exact language you need to say to the defense lawyer to get this fixed. We talked a little bit about offsets. You should know if you're settling a personal injury case that some of these policies, so an offset is like we get money in a third-party case, it's going to reduce what the insurance company is paying you for LTD, okay? Some of these policies say, well, if the offset is for wages, then we're going to reduce. But everything else is not, it doesn't reduce. So as the lawyer, again, if you can just craft some language in a settlement agreement, it says like, none of this is for wages, it's a settlement agreement. The defense lawyer for State Farm, they don't care, right? Most of them are going to be pretty reasonable because it's not really hurt their claim. You just need to be aware of that. Here's the thing on workers' comp, which is why it's in red. It doesn't apply to every policy. But many policies, when you settle for a lump sum amount in your workers' comp case, it's almost always going to be an offset to what they're getting, my client is getting in the long-term disability claim. The question is, if you settle for $100,000, like how many dollars a month is that offset? Does it offset the whole $100,000 right now and the claim goes away? Or is there some other formula? And what you need to know is that many policies say you get to choose. In your work comp settlement, again, the language is all in the article, you want this to be like, this is a settlement for the lifetime. We're getting X dollars, and what do you all call it? Like work comp compensatory, I don't even know your language. Indemnity, I guess. And what you will do when you have the right language in there is you will make the monthly offset for the disability policy dollars, not tens or hundreds of thousands of dollars, but dollars, and that's a good thing. Again, not every policy will do this, but again, my point in being here is just to make you aware that there's issues over here. You don't have to be an expert in this, but you need to know enough, especially when a client comes to ask you, right? And by all means, like call us. My associate is a rock star in this. All right, here's my bonus. So one of the things I guess I'm known for is being a person in the profession who's trying to change the profession, make lawyers have happy lives, rich lives, do good work in the community, all of that stuff. The default should not be misery. So what I've got here, I'll share with you two things, is this is the document that we onboard. Maybe if you could help me on. This is our culture document. We onboard, we hire to this document, we onboard to this document, we fire to this document. And maybe if you guys can just, that's right. I just give this to you as a model of what I think we lawyers, particularly law firm owners, can do to make our lives better. If our lives are great, our team's lives are great, then the clients will be well served, all right? Second thing, I just finished up the Great Legal Marketing Summit down in Orlando a couple weeks ago. We have 18 and a half hours of marketing practice building mindset. We're having, all of those notes have been professionally transcribed. That's in process right now. And we're making 18 and a half hours of notes from our marketing event free, available free to everyone. So there's the last page of this is a QR code. You can get in line. The notes are not ready yet. The website is up. Hopefully it works mostly. And I also have the list from here. But if you are at all interested in making your life better, learning how to market, making your own life better, we are just making these notes for the first time ever available to the world. So I don't know if you have a question, if you have time for a question. That time went by fast.
Thank you very much.
Yeah, absolutely. Yeah.